Good morning, Tony. Mr. McCrone, you're here because you've been accused of one count of resisting an officer without violence. There is probable cause for the charge. I'm going to set you the standard bond I normally would set for this charge, which is $2,500 cash or surety. Mr. McCrone, cash or surety means you can go through a bondsman. You don't have to come up with all the money. And you will get to use the phone in just a few minutes to try to post the bond. Now, Mr. McCrone, if you post it, you'll be released. If you don't post it, I'm asking the jail to put you back on the docket for Monday. If you don't post it, I'll see you Monday.
Judge is doing the basic. Here's your bond. Here's what happens next. And this guy cannot survive 10 seconds without trying to run the courtroom. He's demanding a speed trial right now like this is a fast food window, not a criminal docket. You can literally hear the judge trying to finish one sentence, and he keeps interrupting like the mic is his. This matters because the fastest way to lose a judge is to prove you can't follow the simplest direction. Stop talking. He's not defending himself. He's auditioning for more charges. Congrats, sir. You just speed ran your own freedom.
Hey, bring him back in here. I'm not going to tolerate that last thing. Bring him back, please.
I'll rehab. I'll rehab. No, I'll bring him back. I don't want to talk to him. I'll rehab. I want 2 years of rehab. I'm hooked on dope now.
Mr. McCrone, listen to me. I will not tolerate. Shut up, Mr. McCrone. Stop talking and listen to me. I will not tolerate you using the F word in court. I'm having a contempt hearing right now, Mr. McCrone. We're having a contempt hearing. I'm accusing you.
I'm still your ass. I'm dead man, son. I need 2 years of rehab. I took y'all dope to both now. The judge,
listen to me.
didn't come get it in time. Sheriff didn't come get it in time. I got hooked on dope. I need help.
Mr. McCrone, I'm having a criminal contempt right now. I'm accusing you of direct criminal contempt for the language you're using in front of court, and I'm giving you a chance to offer any defenses that you have. Are there any defenses you would like to have to this accusation? Any defenses you'd like to tell me?
Actually, to it. I had my dog, and he snatched me out of that off the pan.
All right.
I was on the leash.
All right, thank you. I'm finding you guilty of direct criminal contempt. Now we're about to move to the sentencing phase. Is there anything you'd like to say before I sentence you for direct criminal contempt? Anything you want to say?
Nothing.
All right, I'm sentencing you to 5 months and 29 days for direct criminal contempt. Have a good day.
Well, you better ask 2 years for that motherfucker. Because rehab. Right. I'm going to rehab. I'm going to rehab.
You're not going to rehab. You're going to jail. Have a good day.
This is the moment the judge snaps the leash. Bring him back. And suddenly we're in contempt territory. Notice how the judge gives him a chance to defend himself. And he responds with a story about his dog and the officer. That's not a defense to cussing in court. That's a completely different complaint. The judge is saying, I'm addressing your behavior in my courtroom, and he's arguing the facts of the arrest like it's trial day. Then the hammer drops, 5 months and 29 days. And the judge's line is ice cold. You're not going to rehab. You're going to jail. That's what happens when your mouth thinks it's the lawyer.
This is State of Indiana versus James Broadway, cause number 64D02, 2602 F6 1636. State by Deputy Prosecutor Pavlovsky. Defendant appears remotely from the Porter County Jail, along with Attorney Ken Elwood, who appears in person for the limited purpose of initial hearing.
Mr. Broadway, please raise your right hand. I affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
Yes, sir.
All right. What is your name?
Jamie Clifford Broadway.
How old are you?
I'm born on a leap year. My birthday is October 31st. Technically, I'm underage.
All right. Here's what we're going to do. I'm going to advise you some things, and then I'm going to tell you what we're transferring your case. So just sit tight.
All right.
You have been charged in this matter with new offenses. The prosecutor will advise you of those offenses, and then we'll transfer the case to Judge Fish. Mr. Pavlovsky.
Thank you, Judge. State of Indiana is charging the defendant, James Broadway, with 2 criminal counts. Count 1, theft, a level 6 felony. Charge reads as follows. Officer Anthony Macco of the Portage Police Department swears on the penalty of perjury that on February 12th, 2026 in Porter County, Indiana, James C. Broadway did knowingly or intentionally exert unauthorized control over the property of Speedway with the intent to deprive the owner of any part of the property's value or use, and the person has a prior conviction for theft or conversion. A level 6 felony is punishable by 6 months to 2.5 years in the Indiana Department of Corrections. Count 2, possession of marijuana, Class A misdemeanor. Officer Macko swears on the penalty of perjury that on February 13th, 2026, in Porter County, Indiana, James C. Broadway did knowingly or intentionally possess marijuana, hash oil, hashish, or salvia, and the person has a prior conviction for a drug offense. A Class A misdemeanor is punishable by 0 to 365 days in the Porter County Jail. Those are the charges. And I think that last information is a typo. It should be February 12th as stated in the probable cause affidavit.
Now I need you guys to unmute because I had muted the jail before. Mr. Broadway, do you understand what the 2 new charges are that have been filed against you in this case?
Yeah, I just don't understand why this is report county. Report county.
I'm sorry, I couldn't hear you.
I said I don't understand. I understand that, but I don't understand why this is considered Porter County when it's right next to LaPorte Airport. This is LaPorte County.
I don't want you saying else about the location, but it's alleged that you took items from at 5011 in Portage. So that maybe have been closer to Lake County and not LaPorte County, but those are the allegations. All right.
Right.
You have the following rights. You have the right to a public and speedy trial. Your trial could be conducted in front of 6 jurors. You're presumed not guilty. The state must prove you guilty beyond a reasonable doubt. You're entitled to face and cross-examine every witness. You're entitled to have Judge Fish issue subpoenas to have witnesses testify for you. You can never be compelled to testify against yourself. And if you can't afford a lawyer, Judge Fish will appoint one for you. Do you understand your rights, Mr. Broadway?
I understand my rights. I would like to say I have other cases going on, and I am pro se with that.
All right. Hold on, but what I'm going to do first is we're going to address bond, and then I'm transferring your case to Judge Fish.
I don't have money for bond. I was requesting an OR so I can collaborate everything that I have going on because I have 3 cases going on, including this one.
I understand. We're going to address bond first, and then I'm transferring your case to Judge Fish. You'll see him tomorrow morning at 8:30.
You ain't got to tell me about bond because I don't have money. I'm requesting that I can get an OR because I was already OR, but it's a REOR for my last case.
And you allegedly just picked up a new charge. So your bond is $1,500. Your case is now transferred to Judge Fish. You'll see him at 8:30 tomorrow. That will be all.
Yeah, all right, thank you.
Broadway starts out like he's trying to be clever, and immediately you can tell he's going to talk himself into a cage. The judge explains the process. Bond first, transfer next, and Broadway keeps swatting it away. You ain't got to tell me about bond. That's not confidence. That's self-sabotage with a pulse. The legal meaning is simple. Bond is not a debate club topic. It's the court telling you the price of going home. And when you act like the court is your enemy from minute 1, judges stop bending. He's trying to bargain with 0 leverage and maximum attitude.
Yes, sir. I also am pro se in my other court appearances, so I don't validate me getting a public defender. I'm pro se in Tody's court. I have a court appearance coming up June 15th. I also just got a summons for court for theft. It was a level 6 felony for theft, which was a lie. They said they weren't going to press charges because I returned the package that they claimed.
Mr. Broadway?
Yes.
Mr. Broadway?
Yes.
You should listen more. You should listen more and speak less. You understand that? You understand what I mean?
Yeah, I hear you, but I'm stating.
You're in a position here, Mr. Broadway, where it behooves you to be more attentive to the listening part of a conversation rather than the speaking part of a conversation. You understand?
I understand, yeah.
Okay, well then won't you let me pluck this chicken, all right?
Well,
You just
hey,
lost the third
chickens are
spot.
turkeys, sir. Go
You
ahead.
understand, Mr. Broadway?
Yeah, chickens are turkeys, sir. Go ahead.
Why don't you relax for a minute and let me go through this with you?
Here's the classic mistake. He starts freestyling on the record. I'm pro SE. That charge is a lie. They said they wouldn't press charges, and the judge is basically begging him to stop harming himself. Everything you say in court can be used against you, and Broadway is volunteering details like he's filling out a confession form. The judge's warning is perfect. Listen more, speak less. This matters because defendants think talking equals control, but in court, talking without strategy equals damage. He's not defending his case. He's stacking evidence with his own mouth. My guy is acting like the transcript won't exist tomorrow.
F61333, the state says that on February 4th, 2026, in Porter County, you did knowingly or intentionally exert unauthorized control over the property of a Jennifer Badola with the intent to deprive her of any part of the property's value or use, and that you have a prior conviction for theft. Specifically, they say at 2815 Willowdale in Porter County, you exerted unauthorized control over a Laura Geller Compact Foundation by viewing, walking up to the residence and taking the package from the front porch with the intent to deprive her of any part of the property's value or use. And then they reviewed your criminal history and found that you have a prior unrelated conviction for theft or conversion from 2018 in Porter County. Do you understand the allegation, sir?
I understand, yeah. I understand. Also, the officer told me if I returned said package, that I would not be charged.
Don't say too much, Mr. Broadway.
Well,
Don't say too much. What you want to do is just tell me whether you understand the allegations or not.
I do understand them.
Okay, that's all you need to say. That's a yes or no question. You don't need to add anything. Every extra thing you say just damages your defense. Just jeopardizes your defense.
Hold on, sir. Please let me talk.
Come on, I need to drive forward, Mr. Broadway. We need to get through this sometime today.
This is where the judge reads the allegation clean and slow. You stole a package off a porch, and Broadway immediately tries the "but I return it" excuse again. That's not a magic reset button. Returning something doesn't erase the act. It just changes how it might be treated later. The judge keeps trying to pin him to one safe answer. Do you understand the allegation, yes or no? And Broadway refuses to stay in the lane. The tension is the judge trying to protect the integrity of the hearing, while the defendant keeps trying to argue his way out of reality. Every extra sentence is him lighting his own defense on fire. This is the legal version of digging faster because you hate the hole.
All right. Well, Mr. Broadway, you understand the allegations against you in F61333, the theft case?
Not completely, because I'm not able to.
What part do you not understand, sir? Do you not understand the words I use, or do you not understand what they mean?
I understand I'm not being able to go cross-examine my information that you are being told that is wrong.
Mr. Broadway, what they allege you did was steal a package off some lady's porch. You understand that?
Right. And I gave said package back.
That's all you need to answer.
Said that. He said I wasn't going to be charged.
Every other thing you say is harmful to your case. I'm talking
How is it
about
harmful?
so that nobody can hear what you're saying. You understand
How is it
that?
harmful? How is it harmful?
Mr.
That makes no
Broadway,
sense, sir. Look at me in my look at me. You're not even looking at me.
I don't have to look at you, Mr. Broadway. I can barely look at you.
You can barely look at me?
That's right. I'm going to bring you in here. I'm going to adjourn this proceeding and bring you in here tomorrow. We will adjourn the case and...
How about this, sir? How about this, sir?
You said you want to proceed.
Sir, let me say something.
I'll send some stuff out to the jail so you can look at...
How about you just OR?
Through with me tomorrow for a pro se proceeding. And I think we have time tomorrow. We do. Some hour. Well, let's do him at the same time. We'll bring you over with Mr. Conger at 9:30. So I'll adjourn this, Mr. Broadway. We'll see you tomorrow morning at 9:30. I'm going to also send out if you want to represent yourself at court, there's a big, long thing I need to go through with you. I'm going to have my staff. Oh, he's gone? Oh, okay, good.
My apologies, Your Honor. We had to remove him due to his behavior.
This exchange is a masterclass in a judge losing patience the right way. Broadway demands to go home so he can gather body cams and judgments like the court is supposed to pause the universe for his errands. Then he argues about understanding, while simultaneously admitting the core facts again. The judge finally says basically, cool, we're doing this in person, and Broadway gets removed for behavior. That removal matters. The court is telling you, if you can't act like an adult, you don't get the floor. You don't get unlimited chances to hijack the hearing. He wanted control so badly, he got escorted out of it.
So,
Ryan.
we didn't get off to a very good start yesterday. And
No, we didn't.
I didn't feel like we did.
Nah.
You want to sit up in your chair a little bit?
I gotta get some water.
No.
No? I can't. My throat's a little dry.
You'll be okay.
Okay, so you know my body better than me then.
Hey, Mr. Broadway, first thing I want to do then is give you what's called a contempt warning. You ever heard of direct contempt of court?
I know all about court, sir.
You know about direct contempt of court then?
I know you're trying to push a case before the case even got to. So it's like your speedy trial in my case that don't make no sense.
No.
Yeah.
I'm giving you a contempt warning. You know what that means?
You can give me whatever warning you want to. I'm gonna speak my mind, whether you like it or not, sir.
I just want to make sure you understand that when you disrupt this court proceedings, I have the power to hold you in contempt of court. And part of that can be to confine you for up to 6 months in the Porter County Jail just for your contempt. So if you delay the proceedings by acting up like you were yesterday, if you delay the proceedings or try to yell at me or call me names and things like you were doing
I didn't do none
yesterday.
of that. I didn't do none of that. You made a derogatory statement about plucking a chicken, and I said chickens and roosters are turkeys. So I mean, come on now.
I didn't make any derogatory statement to you, sir.
It's on video, so we'll review that because I'm pro se.
What I said was, I'm plucking this chicken.
Right?
You're just watching the feathers fly.
I'm not a chicken.
And what that means is,
Know what it means.
I need for you to allow me to control those proceedings and not continue to be argumentative, not continue to be obstreperous,
Obstreperous? Is that a new word or
and
something?
continue to be interfering with the court proceedings.
Okay, when you speak,
So that's all that means, sir.
first off, you're not
No,
supposed to have...
no. You don't first off me. I first off you.
You
And
off
let
me? Is that what you're saying? You off me.
Let me tell you what needs to happen in this proceeding. If you continue to interrupt me, I'm going to hold you in contempt. I've given you the warning. The next thing is for me to hold you in contempt.
Okay.
And what will come with that is up to a 6-month sentence in jail.
Now it's in person, and the judge starts with a contempt warning. Translation: I'm giving you one last off-ramp before you drive off a cliff. Broadway responds with the worst possible line: I'm going to speak my mind whether you like it or not. That's not bravery. That's a written invitation to jail. The judge explains it in plain English: if you disrupt, I can lock you up for 6 months just for contempt. Broadway then tries to argue about plucking a chicken, like semantics will save him. This is where Judge Authority shines. He's not emotional. He's procedural and crystal clear. And Broadway is basically volunteering to learn what up to 6 months feels like.
What's in there? What are you
Well, that's
talking
what I need to get into with you. But you won't let me. You continue to hinder the proceedings. Every time you talk, you just push things off. Another moment, another hour, another, for your situation, day, because you won't listen. You always want to talk.
Can I say something?
No, you need to listen.
I'm gonna say something. You couldn't look me in the eye when you were telling me on a camera. I'm not for camera.
Okay,
That's all I'm
see
saying,
how I'm looking
sir.
at you right now, sir?
Yeah, I see you.
My camera's right here.
Okay.
So if you're on video,
Yeah.
I have to look right here.
Okay.
My screen's right here.
Uh-huh. I don't
Right?
care about technology, sir. Technology
You
is the
can't look
problem
at
of
you
the
and
world.
look at my screen at the same time.
Okay, well, I'm looking at you. You're not looking at me.
Well, I can't do both. I can't also look at the screen and talk
When
to you
I'm
at the
on
same
camera, when I'm in camera court, you're looking this way, talking to me.
And I don't have to do what you
That's
say,
like,
sir.
5. That's like saying you're talking from somebody else.
So here we are again.
Here we are,
We're
right?
not able to get through your initial hearing.
I'm not here for a murder trial, sir. I'm here for a possession charge. And
I know
pushed
why
on-
you're here.
pushed on a March 20th case that I have.
All right, Mr.
Clymer
Broadway.
put me
I'm holding you in contempt.
Okay, that's fine, sir.
That's
fine.
you.
That's fine. You're gonna see.
This clip is pure chaos. Broadway starts arguing about eye contact and technology like it's a TED Talk nobody requested. The judge is trying to finish the hearing, and Broadway is treating the courtroom like a comment section. The legal meaning is simple. The judge controls the pace, the rules, and the microphone. When you refuse that, you're not standing up for yourself. You're delaying your own case. You can literally hear the judge's patience draining while Broadway keeps throwing childish challenges. And then the judge says the line that ends it, "Here we are again." That's a judge realizing you're unteachable.
I'm sentencing you to 30 days in the Porter County Jail.
Fuck you, dude.
I'm sentencing you to 60 days in the Porter County Jail.
Jail? How about you send me to the old Porter County Jail that's right there? Because where I'm at is next to the LaPorte Airport, sir.
Mr. Broadway, would you like me to add another 30 days?
Why don't you add my name right, sir? My name is Jamie Clifford Broadway. Get that right. My name was changed when we came back from the
another
war,
30
sir.
days. I've
No,
now
you don't.
sentenced you to 90 days in the Porter
whatever.
County Jail.
Whatever.
Once you've
Stop
served-
the county, sir. That's LaPorte County. It's already been
Would
verified.
you like me to add another 30 days, sir?
Fuck you, 30 days.
I'll add another 30 days.
Fuck.
We've sentenced you to 120 days in the Porter County Jail.
This is the nuclear meltdown. The judge holds him in contempt, gives him 30 days. Then Broadway fires off, "F you, dude," and the sentence starts stacking like Legos of stupidity. 30 becomes 60. He keeps talking, it becomes 90. Then he keeps pushing, and it becomes 120. This is the cleanest lesson on earth. Contempt is not a theory, it's a meter. Every outburst adds time. The judge even asks, "Would you like me to add another 30 days?" And Broadway basically says yes with his mouth. Watching him argue while the jail time grows is like watching someone press the increased difficulty button repeatedly. He didn't get punished for the case. He got punished for being allergic to silence.
We're gonna have to get a cause number for that. Oh. And do the detailed order and findings. I'll need a transcript. Are you Mr. Clumpf? All right. You gonna do better than that guy?
The aftermath is almost funnier because the courtroom has to deal with paperwork for the chaos he just created. The judge is talking about cause numbers, orders, transcripts, because yes, contempt requires documentation, and he's doing it by the book. Then the judge turns to the next guy like, "You gonna do better than that?" That's not comedy, that's courtroom survival. The tension resets instantly. One man just torched his own freedom, and the machine keeps moving. Court doesn't stop because you had a tantrum. It just records it and sentences it.